All right, the court is open. Anyone have questions?
Please be seated. Yeah, he's joking here. We're here in our case 1CACV 20-0431, Aloia versus Gore. Each side will have 20 minutes to present your argument to the opponent. You may reserve any amount of time you want for rebuttal, but you'll have to keep track of the time yourself. And because we're socially distanced, you'll argue from your table. You have the podium for that. The clock, however, is still on the main podium. So if either of you need to stand up to look at the clock, feel free to do that. We are recording the argument both in audio and video. So when it's your turn to speak, please identify yourself and your client so that when we review the audio or the video, we can keep everything straight. The video will be on YouTube in a couple of days. We've read the briefs, we've conferenced the case, so we're familiar with the facts and the law. So when you begin your argument, just launch right into what you would like for us to know. Counsel, you may begin.
Thank you, Your Honors. Tim O'Connor on behalf of the appellant, Stephen Gore. The couple of points that I would like to address in our oral argument today. First and foremost is Mr. Gore's position that the trial court erred by not reducing punitive damages to a level that would be less than a 1-to-1 ratio with the compensatory damages. The basis for that argument is twofold. Number one, that the compensatory damages are undisputably substantial. And then number two, Mr. Gore's inability to pay such a high award. Now, as the court knows, there are 3 guideposts that are required to be...
Counsel, when we look at those guideposts and we apply them, don't we have to give at least some deference to the trial judge's evaluation of things? Because as I understand the substantive issue is whether the punitive damages are constitutionally excessive or not. The U.S. Supreme Court has indicated that, generally speaking, although there are a myriad of circumstances that have to be considered, that 4-to-1 is the constitutional limit. Given that, as long as it doesn't approach that ratio, isn't whatever the amount is within the discretion of the trial judge, and how can we say that the court erred in picking 1-to-1 or 1.5-to-1 or a lower ratio as you suggest?
Yes, certainly there is a certain amount of discretion that needs to be given to the trial judge, since the trial judge was the one that sat through the entire trial and heard all of the evidence. Our position is, again, because of the trial judge having looked at and sat through the trial, having concluded, as he notes in his minute entry, that the evidence barely met the threshold for what the compensatory damages were. Those compensatory damages were so high, and I don't think that, or to the extent the judge did not include a consideration of Mr. Gore's inability to pay for those punitive damages, that those 2 factors should be weighed by this court in determining that perhaps the 1-to-1 is still a ratio that is too high and that a lower ratio would be appropriate.
Are there factors that it's clear that you believe the trial court should have considered but the court obviously didn't?
It was an issue that was raised before the trial court, so again, we're in front of this court to reevaluate, look at it with a fresh set of eyes and see that, yes, because of the size of the compensatory damages, as well as Mr. Gore's impecunity, that this court, I feel, certainly has the authority to review what the trial court did, and if it deems that a lesser ratio is appropriate, it has the authority to do so.
We don't even reach the substantive issue, though, if the appeal isn't properly here. Do you want to speak about the trial court's jurisdiction?
Sure, absolutely. If the trial court lacked the jurisdiction or authority to address the issue, then yes, it wouldn't be appropriate for this court to address that. Obviously, the Gore's position is that it was appropriate for the trial court to do what it did in finding that it had the authority, especially when we're dealing with an issue that is the constitutionality of a judgment. The trial court, I appreciated what the trial judge put in his minute entry, talking about, every court, this court included, has an obligation, a heightened responsibility to look at judgments to make sure that they are constitutional. And he felt, and our position is he had the authority through Rule 60B to go ahead and address the issue, despite that the Rule 59 motion was too late. He had the authority, by way of the case law in Rule 60B, to go ahead and address the constitutionality of the punitive damages.
So are you relying primarily on 60B6, the extraordinary circumstances, or are you also relying on B1 and excusable mistake? Both.
I think both are applicable, but I would say the primary one would be the B6, because B6, expressly says, hey, any other reason that justifies setting aside an award, and in this case, an unconstitutionally excessive judgment, that's a justification for setting aside an award. Absolutely.
I thought that B6 generally wasn't used to look at substantive issues. Am I wrong on that?
I would say that the case law leaves it to this court's discretion. And again, because we're dealing with an issue of the constitutional excessiveness of a judgment, it's within this court's authority and power to address that by way of either B6 or B1, because it was a mistake as well in not receiving a copy of the judgment and acting and filing the motion, the Rule 59 motion, in a timely manner.
So, Counsel, it seems like you're suggesting we need to, that the key factor is the magnitude of the error. So, see that let's change the facts a little bit. Say it was 15 or 20 million. 15, does that would it jump off the page in the same manner that the 50 million did, so that the trial judge would have absolutely had the discretion? I mean, at what point, it just seems like a real slippery slope here to do that in the face of long-standing case law, and that we follow the rules. That's why we have rules. And when an attorney or a party doesn't meet those rules, then there are consequences. And we let that fly in the absence of extraordinary circumstances. So help me understand that. Would a lesser error also, say it was just 2-to-1, would the same considerations be at issue here?
I think what the consideration is that it is an issue of whether or not the judgment meets constitutional due process. I think that's the key. If the punitive damages award was a 1-to-1 with the compensatories, the way that the jury decided, I think we would have a different analysis here. But that's not the analysis we're faced with the facts in this case. In this case, we have a unconstitutionally excessive judgment. And with that being the consideration, yes, this court, as the trial court did, needs to act and make sure its judgment this judgment meets constitutional due process requirements, yes.
Could the court, after the verdict came in, couldn't the court on its own have reduced the damages award?
Yes, I believe it has the authority to do so.
Why didn't? I mean, if it was so shocking, so outrageous, why didn't the court see that? I mean, I know this is all Monday morning, we're
Sure.
looking at, we're just I mean, I don't mean to, cast blame on anybody, but it's really hard not to ask why. Why wasn't this done? Why wasn't this done? Why wasn't the docket checked? Those types of things. I'm from my perspective, I don't think for me, 60B1 doesn't move the needle at all. I mean, but 60B6, that's a much tougher call for me. So that's why I'm really trying to drill down on how, I mean, if we were to agree with your position, I just wonder what that means going forward for future cases. I mean, it depends on how serious the error is. I mean, in other words, it seems like you're saying if it's a constitutional error, then you should get the right to, seek a delayed appeal or set it aside. But if it's not of constitutional magnitude, then you're out of luck.
It's a different analysis, absolutely. Absolutely. The fact that it is an unconstitutional judgment, an unconstitutionally excessive judgment, to use your term, that pushes the needle. And
what's your best case law for that? Under 60B6?
Well, under 60B6, I would actually apply a couple of different cases. I mean, you have the overarching cases such as the Olson versus Walker case and the Hawkins case, which talks about when you're dealing with a constitutional issue, the constitutionality of punitive damages. Yes, this court should take a look at it. The other important case is the Hilgeman versus American Mortgage case. And again, that's a case where, while it was under a default judgment, the court was pretty clear in saying, hey, one of our considerations here is the constitutionality of the punitive damages award. And the trial court was not willing to set it aside, and we feel that results in a harsh and unjust result, and therefore we're going to set it aside. It's analogous in the sense that, hey, when you have a constitutional issue, the court needs and has the authority to act to make sure that judgment meets constitutional due process.
Well, counsel, the consideration in Hilgeman and other cases like that is that in a default case, there is no ability to appeal. So if you don't get extraordinary relief some other way, then there's no way to review that. Here, you had the right to appeal, but there were errors in following the rules that precluded a proper appeal. So, are those cases different from this one?
Well, I would just point the court to the fact in the Hilgeman analysis, the court addresses actually three different factors in its decision to set aside the award, one of which being that it was a default and there was no option to appeal. But the other two considerations the court looked at was the fact that it was a constitutional issue, and that these constitutional issues, that it is important for the court to address these constitutional issues. And in that case, while it was default, the court's also looking at the fact that, hey, this was a constitutional issue and we need to address it, and we're willing to step in, overrule the trial court, and set aside the punitive damages award and allow it to be tried on the merits.
Are there decisions from other jurisdictions about constitutionally excessive punitive damages, or any of those examined under the equivalent of Rule 60B6?
Nothing that I came across. I'll admit I didn't do extensive out-of-jurisdiction research on the issue. I was more focused on the ratio issue. but there was nothing that I came across that I saw that expressly addressed this type of situation. I think I have 7 minutes left. I'll sit down and reserve that time for Paula. Thank you.
Thank you, counsel. Counsel?
May it please the court, my name is David Tissell. I represent 10 plaintiffs who prevailed in a jury trial below. I don't want to go into the detail. I know you know the case, but I think it's important that those claims went to the jury on a general verdict form on fraud, intentional infliction of emotional distress, and on the mishandling of body parts. And that as to those clients, each of my clients received compensatory awards ranging from $500,000 to $1.5 million, and each of them received punitive damages of $5 million as well. Today I'd like to focus on 3 main points. The first is that the trial court lacked jurisdiction when it reduced the punitive damages award in this case pursuant to Rule 60. And Judge Brown, if I can follow up on one of the questions that you asked earlier of Mr. O'Connor, as to 60B6, the case law is clear that that really applies to exceptional circumstances. And exceptional circumstances can't be created by the lack of diligence either of the party that has the ability to appeal and the court here, who also had time under Rule 59 to, on its own initiative, sua sponte, reduce the punitive damages should the court have chosen to do so.
So the arguably excessive or extremely excessive amount of punitive damages does not by itself create an exceptional circumstance. I mean, apart from whatever the attorney should or shouldn't have done.
Yeah, I didn't mean to interrupt you. Your Honor, I don't believe that it does, because here the issue is a situation under Rule 60 where someone doesn't have the ability to appeal, doesn't have the ability to challenge in any other way. That's why it's so important that when Mr. O'Connor cites to the case law to support his position, it's only default judgment cases. And the reason that Rule 60B is allowed for default judgment cases, first, the rule expressly says that under Rule 55C, that that's the way that you do it. But that stands to reason, because the only way that you can be heard in a default case on challenging that issue would be through a 60B process. I think it's also important to note that constitutional issues are waivable. Again here, this was something that was up for appeal, that was not challenged, not even criticized by either Mr. Gore or the trial court. The judgments were entered, and I understand that they are still pursuing the 60B1 approach, so I think it's important then to point out the Chung case and the fact that the party does not receive notice directly, but the notice is actually existing on the computer service, on the docket, for a period of time, is not sufficient for 60B1 relief. And in Chung, the time that the party waited, I believe, was 60 days, and here it was far longer than that. And that has been the only basis under 60B1 that has been asserted in this case. So it would be our position that Rule 60, the court's actions were out of time, and it lacked jurisdiction at the time that it did that.
Counsel, let's back up a second.
Yes.
So at the start, so because our standard of review is abuse of discretion, right? I mean, we review all 60, Rule 60 rulings for an abuse of discretion. What does that mean here in this context? Because we have a judge who has been handling this case for quite some time, who sat through the entire trial, who knows the players and the attorneys before him and everything about that, and makes this determination that it was appropriate and it was an extraordinary circumstance under Rule 66. Why isn't the judge entitled to at least some deference on that, on making that call?
Because I think this court's duty, and I appreciate the question, but I think this court's duty is also to apply the law, and there is no case that anyone has been able to cite in where 60B or 60B6 anywhere, not just in Arizona, but across the country, has ever been used and applied as broadly as to say that if there is any constitutional issue, that the trial court can raise it at that point in time. In fact, this was fully briefed, but I think it's important to note that there is no authority that expressly says that a trial court can raise constitutional issues at any time, which also would be against the 60B6 argument, Your Honor.
Well, counsel, so the consequence of your argument would be that the defendant could be stuck with an extraordinary punitive damages amount that, if properly challenged, would be unconstitutional, but because of irregularities or errors by counsel, that's unfortunately just too bad.
Well, I think my response to that is that the rules have to have meaning here, and constitutional issues are waivable under the law. And if this were a situation where a party did not have the ability to appeal or challenge a constitutional issue, and the only way that they could get there, that would be a different circumstance than what we're facing. But when you have the ability to appeal, or you have the ability, as the trial court did, to do it sua sponte on its own, if it so shocked the conscience, if it was so unconstitutional, and neither took that, and for months allowed the judgments to remain in place, and then the trial court, in terms of deference to the trial court was very clear that the Rule 59 motion was untimely, and struck that, and also that there was no basis under Rule 6b2 for that time to be extended. And so when that happens, whether it's an unfortunate circumstance or not, one can't create exceptional circumstances under Rule 60b6 by their own lack of diligence. Otherwise, you would swallow up the meaning of Rule 6b2, and as the court is well aware from their questions earlier, there's a very intricate scheme under Rule 59 in terms of timing that would basically go out the window if all you had to do at any point in time was say, I had a constitutional issue, but under Rule 59, because the issue here is an issue where they're claiming there were excessive damages, and that is an itemized Rule 59 motion that can be brought if you're challenging excessive damages. If I then just call it constitutional to avoid, you are now undoing the scheme that has been put in place in terms of the timing that is required under the rules.
Counsel, the point you made makes sense to me. What's the best case? What's the best authority you have for that notion that you cannot create exceptional circumstances by your own lack of diligence? Is there a case that says that?
I think, Your Honor, if you really want
us to say that.
Well, if you review Moore's, and if you, and I know it's federal practice, but if you review Moore's, and you actually, as to when, I think my point, Your Honor, is the absence of cases where that has been allowed is what is most persuasive here, is that 60b6 has never been used to the extent that it was used by the trial court here. That is for the situation, again, when we talk about exceptional circumstances, where a party is in an unfortunate situation, but they didn't create that situation for themselves. If they created it by missing a deadline, or the trial court missed a deadline, then they can't use that as exceptional circumstances under 60b6. That just hasn't been done in any case that we've been able to find nationwide.
So is the remedy for the problem not Rule 60B, but a malpractice claim for the counsel now doing what they reasonably should have done? And if that's the case, how in the world do you get a recovery on excessive punitive damages?
Well, I don't know what the remedy is for the client who's involved. I'm talking about the application of the law in terms of my clients and their situation. And whether it's recoverable or not is a wholly different issue. But I think this is important too, and I don't want to lose my time on talking about the constitutionality. But one of the arguments that I heard this morning was that you should reduce it because of perhaps Mr. Gore's ability or inability to pay the amount. And that is contrary to what the law of punitive damages is here in Arizona. It is not only to deter Mr. Gore, but it is to deter anyone in this industry, in the body broker industry, from carrying on this kind of, this is what's going to happen to you, and these are the damages that you will be exposed to if you operate in this way under Arizona law. And as was talked about and was in the trial record, this is a billion-dollar industry. And so there is a reason, there is a purpose why punitive damages need to be enforced to send a message to the world at large and to people that are going to come to Arizona that they can't practice in this way and cause the devastating psychological harm that our clients suffered in this case.
So I raised the issue of malpractice because if there is an avenue for a client with an unfortunate situation to achieve recovery, that at least for me, it would help me inform what the definition of exceptional circumstances is.
Okay. Thank you. Looking at my time, I would like to address, are there any other questions on the procedural point? Okay. I would like to turn to the constitutional arguments. And first, I think the first thing that is important is that this court, when it's reviewing the constitutionality reduction or imposition, is reviewing it de novo, and is to look at the record and to see what the record actually showed. And what the cases in Arizona have done following the State Farm Supreme Court decision has basically followed a reprehensibility scale. And that scale is on a low to moderate to high scale in terms of the reprehensibility. And the most important element is the degree of reprehensibility, and there is a 5-part test that is used. And I would submit, Your Honors, that most, if not all, of the 5 elements to review are met in this case. And those cases where reduction to 1-to-1 has occurred are cases where it's either purely economic harm, or there's one or at most 2 of the 5 elements that are present. But here all 5 are present, and I'd like to go through those. The first element is physical, emotional versus economic harm. Here, this is not an economic case. This is not about our clients paying money that they need. The cases in which punitive damage awards have been reduced to 1-to-1, Nardelli is a perfect example where you have someone who has a bad faith insurance claim because they want replacement of the car, and instead they get the cost of repair, and then there's a fight about that. That was solely about economic damages, and that would be appropriate. But here you have our clients who testified to the severe, debilitating nature, the intrusive nightmares, the PTSD symptoms that they were suffering from, not only their testimony, which is in the record before you, but also the testimony of expert Dr. Nicoletti, who testified. And what is also important in this case, which is in the record but has not been discussed today, is this jury, there were 21 plaintiffs in this case. This jury was not a runaway jury that just willy-nilly awarded damages without thought or going through. There were the majority of the plaintiffs that proceeded ended up with defense verdicts in the case. And they took significant time to break down the amount of damages. But the damages on punitive damages is the same as to each, which is very important because it's based upon the same conduct and the same message that they were trying to send. The second item on the reprehensibility scale is indifference to the health and safety of others. And again, in the record, Mr. Gore testified at trial that he knew that our clients, the plaintiffs, could suffer extreme grief had they known what was going to happen here. But he did it anyway. And what happened, what the record shows, is that our clients were promised through brochures, through representations, that if they donated their loved ones' bodies, that the bodies would be used for medical and scientific purposes, they would not be sold, and that they would be only used as directed by the donors and their families. And as to these clients that got awards, what was shown is that didn't happen. The bodies were cut up and sold off of a price list to body brokers and to other end users to be used improperly. And that caused severe and significant harm to our clients. This included the third item, was the target of the conduct financially vulnerable? And we agree that the actual financial condition of our clients was not at issue in the trial court below, but the marketing materials that were used when this was sold this was a viable alternative for people who could not afford to do proper burials and funerals, something they could do to do some good with their lives or with their families, loved ones' lives, when they couldn't otherwise do it. The fourth item was repeated actions or an isolated event. And I would submit this is what separates this case from the cases where reductions have been made, or significant reductions have been made in the ratio that is applied. In the cases where one-to-one has happened, it's a one-off situation. It's one situation where it happens in a certain period of time as to one client. Here, the conduct at issue that our clients suffered from is conduct that occurred over a several-year period of time with hundreds to thousands of different families and potentially exposed to numerous people beyond just the plaintiffs who recovered awards here. And the final item is intentional malice, trickery, or deceit versus accident. And we agree that while Mr. Gore may not have intended to harm any of the individuals here, he pled guilty to a felony and felony criminal enterprise in this case. He lied in the record. I'm not characterizing it. He agreed that he lied to the New York board in order to get a license to be able to work in the body broker business. So there are elements, while there's recklessness and negligence as a part of this, there are elements of intentional conduct as well that are interwoven here. And so I would submit, Your Honors, that this falls on the highest end of the reprehensibility scale, which would require that there be less deference or less scrutiny, I think is the proper word, in terms of the constitutional review of what the jury thought was the appropriate measure of damages in this case.
And so I think that these arguments were made to the trial judge, yet he found that the reprehensibility was merely moderate.
Well, I would respectfully submit, as you would probably not be surprised, that I disagree with that decision, and that's why I would go to the standard of review that you have for this issue, which would be a de novo review based upon the review of the actual record in the case. And I would also submit that if you read the opinion that the court respectfully may have either misconstrued or misunderstood. For example, he talked about the physical element and saying there weren't physical injuries here, as opposed to looking at the case law, which has talked about physical in terms of not only a broken bone, but also the psychological trauma that people suffer, which was the major component of what happened here. There also is not a detailed analysis of these 5 factors, including the several-year period that this scheme was going on and the thousands of people that were exposed to it. So I would submit that I agree with Your Honor's characterization of what the trial court concluded, but I would submit it's not supported by the record, and that you have the ability through de novo review to correct that at this point in time. I only have a minute left. If there are any other questions, I want to make sure I give the opportunity before I close.
No, thank you.
Thank you, Your Honors. I appreciate the time today.
Thank you. Rebuttal?
Thank you, Your Honors. Just a couple of points. Counsel has indicated that the wealth of the defendant is not an issue or a consideration. I would disagree with that. Looking at the Hudgens case, the court specifically said Plaintiffs persuade us that Southwest Airlines wealth warrants a more substantial punitive damages award, so the wealth of the defendant is in fact something that should be considered by a court in determining the appropriateness of a punitive damages award. With respect to the analysis about whether or not the punitive damages were constitutional, one of the issues obviously is the reprehensibility of the defendant's conduct. The trial court sat through the entire trial, heard all the evidence. I would certainly submit that the trial judge should be given deference when he determined that, or at least he characterized it as in the middle range of reprehensibility. Obviously, Mr. Gore's focus is more on the other guideposts, and that is the disparity between the compensatory and punitive damages award. Looking at the disparity with respect to some of the plaintiffs, it's a 10-to-1 ratio. Obviously, that does not meet constitutional dictates. The other two is about a 6.5 and a 3.5 to 1 ratios. Again, our position would be at least the trial judge felt 1-to-1 was an appropriate ratio. Our position is something less than that would be appropriate, again, because of the sizable compensatory damages as well as Mr. Gore's impecunity. And that is all, Judge, unless you have any other questions.
Thank you, counsel. We appreciate your argument.
Thank you.
Today. We'll take this matter under advisement and we'll issue a decision in due course. Thank you. We stand adjourned.